Is it asking too much to have a president running the country who was born in this country from parents who are citizens and thus was not raised as a citizen of the world, so to speak, but as a citizen of your nation, looking out for the interests of your nation, having the perspective of one who is thoroughly enculturated in your nation, in their home, in their life, in their orientation. They were Americans running America. Is that too much to ask? I think the media and many on the globalist side of things would not just say, yes, that's asking too much, but holler yes, yell yes, that's asking too much, and also say a lot of other sort of insulting, pejorative things about you if you suggest that that's not asking too much. I don't think that's asking too much. And I don't say that as a nationalist. I'm not a nationalist. I am a localist. I believe that it should matter a lot less who the president is. I believe that states, there should be 10 viable political parties in every state. And that way it's not an emotional trauma if you decide one is not representing you well and you want to switch, because there's someone to switch to besides the person you've been taught to hate all your life. Our present two-party system is toxic, and that is sort of one of my main themes. So I'm not saying what I'm saying here because I have a horse in the race. I'm saying it because I believe it's true. It is not too much, regardless of what, and I'm telling you where I'm coming from before I get into the details of why Kim Wong Ark does not save those who say it's okay. If you're born on this soil, you are a natural born citizen and you're eligible to be president under Article 2 of the Constitution. And in my studies and my research have shown that that's not the case. That really, it's hard to say with certainty. A court should look at it. A court needs to look at this. I don't believe they will. Our courts did not step up and do their job when certain suits have been presented in the past that they should have looked at. They dismissed them for lack of standing. They punted. They did not live up to their responsibilities. And so because of that, questions continue to linger. Whereas if they had done their job and addressed these things, like I'm about to try to do today, then we could have some closure. So that's where I'm coming from. I'm coming to you as a person who believes local government is the way most of our decisions should be made by people that we could see if we need to. And the further up you go, the less important government should be. The presidency should only really deal with foreign nations, the border, and things of that nature. And really, we should take away their power to start all these senseless foreign wars. So I'm not a globalist, and so I don't believe it's too much to ask that our president be a person who was born in this country from parents who are citizens of the country. Now, in the case of Kamala Harris, she does not meet that standard because even though she was born in this country, neither of her parents were citizens at the time of her birth. Her mother, for example, was here on a student visa which had expired when she gave birth to Kamala Harris. So, of course, in this hyper-polarized political situation, people, they either grasp on that and say, well, okay, yeah, you're right, without overlooking the facts because it's what they want to believe, or people start, hollering, you're a bigot and you must be saying it because she's a black woman and you're a racist and a terrible person, and just start screeching all kinds of nonsense. But I'm just going to show you what the ruling says here. We're going to go through some key points from Kim Wong Ark, and I'm going to show you why it does not resolve the issue of, is a person born from alien parents a natural born citizen for purposes of Article 2 in the Constitution. So here's the real problem. The founders said no one who, except a natural born citizen, can be president of the United States. But they didn't define natural born citizen. And we have a strong line of evidence that there was a book that was in circulation then. They had it. They referred to it. When some reporters came into George Washington's office in New York for the first time, it was open there on his desk. Thomas Jefferson had it. Ben Franklin said we relied on it a lot. And that is the Law of Nations by a guy named Vattel. And even the words, the Law of Nations, appears in Article 1, Section 8. Now, it appears in a different context. It doesn't say Law of Nations next to the Article 2, where it talks about the qualifications for president. But in Article 1, just about immediately before that, it does say offenses against the law of nations, and it capitalizes law of nations as if it could be referring to a book. However, their style was to capitalize many things which we would consider like inappropriate. There's no reason to capitalize that. So the jury should be out, the courts, to see whether are they talking about the definition of natural-born citizen from Vattel's Law of Nations. The jury should be out, I say, but the jury's not out because the courts aren't looking at it. They're abandoning their duty, they're not doing their job, and they're leaving this hanging over us. His definition of a natural-born citizen in the Law of Nations, which he was holding out as saying, this isn't the law of any one nation, but this is the law of generally of all nations. He derived it from natural law and from treaty. The natives or natural-born citizens are those born in the country of parents who are citizens. And that's it. And it's very simple. If you're born in the country and your parents are citizens, you are a natural-born citizen. Now, this isn't something that birthers, a pejorative label for people interested in upholding the rule of law, in my opinion. Birthers just came up with because they hate Obama because he's black. So stop being stupid. It's really unhelpful just to sort of be dismissive like that and not look at any of the evidence. Throughout history, this has been an issue. In the 1916 campaign, there was a guy named Charles Evans Hughes. He was beat. Woodrow Wilson beat Charles Evans Hughes. But Wilson's campaign manager penned an article that appeared in the Chicago Legal News. So it was a sort of an important legal publication. It was after the election even. So it wasn't even a case of I'm writing this because I want a leg up in this election. Maybe he was doing that, but they didn't publish it until after the election. Why would they do that? Because they thought it was an important legal point, and they were a legal journal. So they published it. And Long, which is Wilson's campaign manager, he said Hughes was ineligible because his father was not yet naturalized at the time of his birth, and therefore still a British citizen. So Hughes, although Hughes was born in the United States, was also, according to British law, a British citizen. So he had a dual nationality. Yeah, he was an American citizen because he was born in America, but he was also a British citizen because of English law. Therefore, he had double allegiance. Therefore, he was not a natural-born citizen. So he said his point was if you owe allegiance to more than one nation, you're not a natural-born citizen of the United States. In other words, he was drawing in principle from what Vattel was saying. Vattel was saying a natural-born citizen is someone who, by nature, they do not have any divided allegiance. Both their parents are from the same country, and they are born in the country. There's no doubt where their allegiance lies. So that is the gist of the argument. And by the way, like Chester Arthur, there was some dispute about whether he was a natural-born citizen. Part of it was because they thought he was born in Canada, which he was not. And he himself might have been floating part of the rumors that he was born in Canada. He might have had a hand in it. But that was misdirection. What was the real issue? Chester Arthur's father was also an Irishman and therefore English citizen at the time Chester A. Arthur was born. So I think with Arthur's case, there was a little misdirection. He sort of directed things towards where was I born? Was I born on the soil of the United States? And so people weren't looking at this other issue. Well, wait a minute, were both of my parents citizens at the time I was born? His father, by the time he ran for president, his father was a U.S. citizen. So people didn't think about it. But in the case of Charles Evans Hughes, even though he lost to Woodrow Wilson, they were thinking about it. So this issue, it's been out there. It's been a valid legal opinion for a long time. It's not you birthers have just come up with this because you hate black people or just something stupid like that. So that's one side of the story. But there's another side of the story. There's a court case called Kim Wong Ark, United States versus Kim Wong Ark. And that case lends support for the idea that if you are born on United States soil, you are eligible to be president, regardless of the immigration status of your parents. So let's look at Kim Wong Ark. First, let's look at the line of reasoning that supports this idea that if you're born in the U.S., you're a natural-born citizen, no matter, with a couple of minor exceptions, like if you're a diplomat or if you're a part of an invading army, your father was a part of an invading army, you are a natural-born citizen. So let's look at that. So the Kim Wong Ark ruling is a huge ruling. It's got well over 100 paragraphs to it. And they did a great job of researching and a great job of writing things out. But you have to ask, what question were they trying to answer in the case? In that case, Kim Wong Ark was born in the United States to foreign-born parents, and he left for China for a trip, but it was always meant to be a temporary trip. And then he came back, and they didn't let him back in because they said, you're an illegal alien. You don't have permission to be here. And he said, but I was born here. I'm a citizen. And so that went to court, and the courts ruled, yes, he is a citizen. And they pointed to English common law, and most of their examples in these over 100 points, most of their examples were on the basis of citizenship. They didn't use the term natural-born citizen. And so I would say that natural-born citizen implies a higher standard of fidelity to the nation than citizen. But some examples in Kim Wong Ark even segued over into the term natural-born citizen. And here's how they did it. They didn't refer to the Constitution. They didn't refer to U.S. law. They referred to English common law. And they said, look, when the framers wrote the Constitution, they relied on English common law a lot. And they did rely on English common law. I would say they also relied on, Adam Smith's The Wealth of Nations, John Locke. They relied on Vattel's Law of Nations. But English common law was one of the things they relied on. And so they cited a circuit court judge, Justice Swain. And he said all persons born in the allegiance of the king are natural-born subjects. And all persons born in the allegiance of the United States are natural-born citizens. Birth and allegiance go together. Such is the common law, and it is the common law of this country as well as England. So that was in paragraph 23 of U.S. versus Kim Wong Ark. And so they say, see, there you go. By common law, because he was born in England, he's a natural-born subject. And natural-born subject is like natural-born citizen in the United States. Ergo, he's a natural-born citizen. That's the reasoning. And the other point is the 14th Amendment. The 14th Amendment grants citizenship by birth on U.S. soil, even if your parents are not citizens, with few exceptions. Again, if you're a diplomat, if you're an Indian, if you're like Amerindian, if you are part of an invading army, if you're here at the behest of a foreign government, not just people who have immigrated from a foreign country with no intention to go back. If you're here and you're born here, you're a citizen by virtue of the fact you're born here. But that is not say natural born citizen. Most of the points in Kim Wong Ark do not say anything about natural born citizenship, because that wasn't the questioning they were examining. They were not questioning whether Kim Wong Ark was eligible under the Constitution for president. They were arguing whether he was eligible to be a citizen and the normal civil rights and protections of being a citizen. Until I was 40, I was not eligible to be president. Until 1920, women were not eligible to be president. They were still citizens. They still had all the rights of a citizen. They were not eligible to be president. If the president was from one state, you couldn't be the vice president because they had to be from different states. So there are different qualifications, political qualifications, to do with holding the office of the president that have nothing to do with our rights as a typical citizen. So in other words, and this is very important, I'm going to come back to this, Kim Wong Ark was deciding the question that Kim Wong Ark was deciding. He was saying, does he have civil rights? The other question is he eligible for president? That is a separate question. And that is very important. It's very important to understand that distinction. So here's the case then, that he's a natural born citizen. Now, you have to ask yourselves, I'm probably sure some of you, you're more thoughtful when the wheels are going off and turning in your head right now. Wait a minute. In English common law, we're natural born subjects. Is that really the same as natural born citizens? And even if it is natural born citizen, does that apply to president? Like, those subjects didn't even have a vote on who the king was. They didn't even have an office of president. If you're thinking that, you're on the right track. But we're going to get it from the ruling itself. We won't have to make up our own reasoning to answer that question. There's other things in the Kim Wong Ark ruling that take care of that for us. So there's the point in favor. Now let's go to the other side. Let me talk about why the Kim Wong Ark ruling does not help those who say if you're born on U.S. soil, you're a U.S. citizen and eligible to be president. It does say that you're a U.S. citizen if you're born on U.S. soil, but it doesn't necessarily mean you're a natural born citizen under Article 2. It's talking about what the 14th Amendment says for our civil rights, not our political prerogatives. Now, let's take a look at that. So here is the opinion from paragraph 12 of United States versus Kim Wong Ark. And it's a little bit long. I ask you to bear with me, though. It's very critical to understand what the distinction is that is so important. The law of England and of almost all civilized countries ascribe to each individual at his birth two distinct legal states or conditions. You mean this is more complicated than they were born on U.S. soil, therefore they're natural born citizens? Yes, it is more complicated. The truth is often complicated. The facts are often complicated, and they're often inconvenient. For people who put agendas above truth, they're often inconvenient. One by virtue of which they become the subject of some particular country, binding him by the tie of natural allegiance, and which may be called his political status. Another by virtue of which he has ascribed to him the character of a citizen of some particular country, and as such is possessed of certain municipal rights and subject to certain obligations, which latter character is the civil status or condition of the individual, and may be quite different from his political status. I'm going to stop here and interject. When England was saying, if you're born here, you're a natural born subject, they also said some things about people born to British citizens overseas. They tried to make everybody a natural-born subject. If you were a monarchy, which England was until, they've worked their way out of it more and more, but in this time they were a monarchy, you want as many people as possible to be your subjects. So you define the term broadly. Hey, if you're born here, you're my subject. If you're born of one of my citizens overseas, you're still my subject. It's just natural that we see it that way because we're building an empire. The Second Amendment was trying to do the reverse, or not the Second Amendment, but the Article 2 of the Constitution in defining who could be president. It wasn't trying to say we want as many people as we can reasonably construe to be president. It was saying we want to limit who can be president. So the British trying to define natural-born subject broadly fit their imperial ambitions. It fit what they were trying to do. But in terms of what the founders were trying to do with the second Article 2 and defining who could be president, they were trying to narrow things down. So you see, not only is natural-born citizen used in a different context than natural-born subject, and we're going to get into that some more as we go, but they were trying to do different things, the exact opposite things with the term. So equating the two for civil rights purposes is one thing, but equating the two in terms of who is eligible to be president is another. And that is what paragraph 12 from U.S. versus Kim Wong Ark that's the point it's making. There's two distinct states here. They're ruling on Mr. Kim Wong Ark's civil state, not his political state. So they don't have to get into the intricacies of, well, where were his parents born? How much allegiance did they have to China? What were the conditions of it? They don't have to worry about all that because they're not deciding his political status. They're not deciding whether China still has a hold on him or not. They're just deciding, is he entitled to be a U.S. citizen and thus let back into the country? That's what they're saying here. So let me go on. You got two distinct legal states or conditions: his political and his civil, and they can be quite different. And then, while maintaining the civil status, is universally governed by the single principle of domicile. In other words, where you were born. The criterion established by international law for the purposes of determining civil status and the basis on which the personal rights of the party, that is to say, the law which determines his majority or minority, his marriage, his succession, his testancy, his intestacy, must depend. He yet distinctly recognized that a man's political status, his country, and his nationality, that is, his natural allegiance, may depend upon the different laws in different countries. So when he did this, he evidently used the word citizen not as equivalent to subject, but rather to inhabitant. And he had no thought of impeaching the established rule that all persons born under British dominion are natural-born subjects. So what they were doing was they were dealing with an objection to the U.S. was making a case. The prosecutor was making a case and saying, look, there's this man, and I think his name was Lord Westbury. Lord Westbury says there's two distinct legal states here. And they said, yeah, there's two distinct legal states, but he's still a citizen by birth, but he can have it, but that's for rights as a citizen. It's not necessarily his political state. So we're not, the fact that Lord Westbury was trying to say you can be a citizen and in one legal sense, but you can have your allegiance to a different country in another sense, we acknowledge that's true, but in Wong's case, it doesn't matter. It's not what we're trying to figure out. But guess what, folks? In the case of the presidency, that does matter. It does matter. And it's not reasonable to think that the founders would think that it wouldn't matter when they were writing Article 2. Okay? So that's one reason why Kim Wong Ark does not help those who say, yeah, they're all eligible for president. If they're born here, they're eligible. Let's go on. And this one is general. This one is well known. But it is also mentioned in this particular case, U.S. versus Kim Wong Ark. And so since that's the case, everyone is using to say, oh, it doesn't matter. They've sorted it out. He's a citizen under the 14th Amendment, so on and so forth. It says, in weighting a remark uttered under such circumstances, it's well to bear in mind the oft-quoted words of Chief Justice Marshall. It is a maxim not to be disregarded that general expressions in every opinion are to be taken in connection with the case in which those expressions are used. What is he saying? He's saying that because we're ruling something in this case doesn't necessarily mean it applies to another case in that way. You have to sort out the context. You can't take a simplistic approach in these things, as people on both sides are trying to do. You can't do that if you're going to find out what the real meaning of the words are, if you're going to find out what the truth is, if you care about the rule of law, if you care about justice. It says, if they go beyond the case, they may be respected, but ought not to control the judgment in a subsequent suit when the very point is presented for decision. The reason for this maxim is obvious. The question actually before the court is investigated with care and considered in its full extent. Other principles which may serve to illustrate it are considered in their relation to the case decided, but their possible bearing on all other cases is seldom completely investigated. That's right. Kim Wong Ark was not investigating whether Kim Wong Ark was eligible to be president under Article 2. It was investigating whether he had the right as a United States citizen to return to the United States. It doesn't apply. It's not the same kind of case. The people that are saying that are ignoring what's in the case itself when they tell you that, or they're cherry picking is probably really what they're doing. They'll show you a snippet from the case like the one I showed you, which said, hey, we get it from English common law, and natural-born subjects are anybody born in England, and a natural-born subject is like a natural-born citizen, ergo, he's okay. No, that's wrong on several levels. And one of the levels is the question Mr. Ark was examined, or the question concerning Mr. Ark was not the same as a question of, are you eligible for president? But it goes on. Let's go on. One more. They keep saying the 14th Amendment, they being the people that want to globalize everything and think, the natural-born citizen, doesn't matter what the founding fathers thought. The Constitution changed all that with the 14th Amendment. And Kim Wong Ark, of course, was after the 14th Amendment. They were considering what the 14th Amendment said when they made the ruling. And it says the real object of the 14th Amendment of the Constitution, and this is from the ruling U.S. versus Kim Wong Ark, the real object of the 14th Amendment in qualifying the words all persons born in the United States by the addition and subject to the jurisdiction thereof would appear to be and to exclude by the fewest and fittest words, besides children of members of Indian tribes, standing in a particular relation to the national government, unknown to common law, the two classes of cases, children born of alien enemies in a hostile occupation and children of diplomatic representatives from a foreign state. So what they're trying to say is, the prosecution was arguing Mr. Kim Wong Ark was not subject to the jurisdiction thereof because his parents were Chinese. And they were saying, no, that doesn't matter. It doesn't matter for the purposes of the 14th Amendment. But the 14th Amendment doesn't use the phrase natural-born citizen. It just says citizen. It says all persons born or naturalized in the United States are citizens of the United States and the state in which they reside. So it's not about what a natural-born citizen is. The 14th Amendment did not purport to define natural-born citizen in Article 2. It never addressed that issue. Therefore, what is in Article 2 must prevail by any reasonable standard. In the 14th Amendment, it was written most directly so that freed slaves would be citizens. and be granted the rights of citizens. But again, not all citizens had the right to run for president. Females at the time did not have the right to run for president. Persons under 40 did not have the right to run for president. Just because you were a citizen and you had the rights of a citizen didn't mean you had the right to run for president. There were further restrictions in the national interest, the common good, or so they thought at that time. So that was the point here is unknown to the common law. I've got that underlined. In other words, they're saying there's three classes of people that even if they were born here, they're still not citizens. One of them is the children of foreign troops that are occupying hostile occupation. The other is if you're children of diplomatic personnel, or if you're basically here on a mission from a foreign government and you have a kid while you're here. And that kind of actually could apply to Barack Obama too, because his father was here at the behest of a foreign government. You know, he was a student, but he was studying to be a part of that government. But I digress. The point is, the third class is the members of Indian tribes, because they had a standing in relation to the national government that was unknown to the common law. In other words, English common law doesn't help you here, does it? Because England didn't have all these Indian reservations carved out, giving birth to all these people that, you know, they're kind of their own nation, but they're really under our control too, and English common law doesn't account for it. So in America, the children of Indians, they're born in U.S. territory, they're still not United States citizens. That's what the other rulings, and those rulings are listed in Kim Wong Ark, say. There's this guy, he wanted to be a U.S. citizen, he identified, but they said, no, you're an Indian. And they're saying, look, the normal rule that says if you're born on U.S. soil, you're a U.S. citizen, doesn't apply to Indians. The common law doesn't work here because this is a situation that is not known in common law. Well, guess what else is not known in common law? The qualifications to be president in a democratic republic are not known in English common law because they had a king at the time, and they still don't have a president, actually. So it is no help. Kim Wong Ark is absolutely no help to those who say, you know what, they're eligible. Kamala Harris is eligible. Barack Obama was eligible. And the next person we have that was, as long as they were born on U.S. soil, doesn't matter the status of their parents, they can be a citizen of the world in their heads, but as long as they're born on U.S. soil, they're eligible to be president. Those who have that position say Kim Wong Ark helps their case. It does not help their case for the reasons I described. And Kim Wong Ark was considering the 14th Amendment. The 14th Amendment applies to citizenship for civil rights, not political status, which would include, are you eligible for president or not? Let me wrap this up, folks. Thank you.